So, Harry Littman, it does indeed seem that Donald Trump's joint address statements about Doge and Musk would come back to haunt him and backfire, where he says Doge is a department that we created and Elon Musk is leading it and running everything. It was actually cited in a recent opinion that's really important to gaining access to information about what the hell is Doge doing. A federal judge in Washington, D.C., has ordered the urgent release of Doge records, citing, quote, unprecedented power and unusual secrecy. It's Judge Cooper, federal judge in Washington, D.C., hearing this public records case brought by the group that many of our viewers and listeners know. They're called CREW, Citizens for Responsibility and Ethics in Washington versus U.S. Doge Service, or USDS, whatever they're calling themselves. And what CREW said is, look, we made this public records request originally, and it seemed that Doge and the agencies that it worked with as well were going to turn over the records. They then did an abrupt about face. They then are making this argument that they don't have to turn over records and they're impervious to FOIA requests, and they're not. They hold exceptional power over what's going on in our government, and the Freedom of Information Act request applies to them. Judge Cooper goes through this analysis of the various requests that are being sought by CREW, and this includes, communications with Office of Management and Budget and the emails and the messages about what was taking place. Doge does not want any of this being released. And the court does this analysis. One of the things it says as well is, yeah, we've got evidence of what Trump was saying as well during that State of the Union or joint address, whatever they're calling it, where he was mentioning the incredible powers of Doge. And they shouldn't be free from Freedom of Information Act requests. The judge doesn't cite the specific date, but says it needs to be done expeditiously. The judge said a status report in the next 10 days or so for the parties to say when these documents will be turned over. I'm going to guess that Doge is going to appeal to the DC Circuit and try to bring this all the way up to the United States Supreme Court. But Harry, go through what this decision's about. How big of a deal is it? The analysis the court went through. Would love to hear your take on it.
Sure, and thanks, Ben. I think it's a pretty big deal because it's the first one. There have been different kinds of attacks on what Doge and Musk are doing, but really, this is the one that goes to the heart of the problem, which is, as Judge Cooper says, huge power, complete secrecy, lack of transparency. What the hell is going on? This is what the Freedom of Information Act is about. Citizens have a right to know what their government is doing, except subject to certain exemptions, which Cooper says that's fine. We just want their basic information. And what he technically holds is, and it's important because, as you say, the State of the Union and elsewhere, they've been doing this two-step about both what Doge is and who Musk is. And, anywhere from super important kind of, running the whole executive branch down to, just some, helpful advisors who check in with the president every once in a while. For purposes of FOIA, Cooper says, it's an agency, and that means they're subject to all kinds of holdings. And then also B, it's under FOIA exigent. CREW, as you noted, they're repeat players, and they've been really pretty clever. They tie it to the appropriations process, which on Friday, as you know, is when money runs out. And the people's right to be informed, to participate in the democratic process for the very basic governmental function of how Congress allocates money. They need to know all this stuff about Doge because it could be the way things have been going. Congress appropriates and Doge just says, never mind. So first of all, it's also an elegant opinion, pithy. Cooper's a good writer, and he has some very kind of telling statements about how the administration generally is trying to have it different ways with Doge as it suits its kind of interests. trying to sort of bob and weave. And he goes through a lot of the public controversy involving Doge, but it fits in exactly to what he's holding, which is the people have a right to know here. So besides that, it's a really nicely written 37 or something page opinion. He really does go through it. I think it's important because it's the first one that gets to the heart of the real problem here, which is just the, government by new entity, whoever the hell they are, with this big question mark in the middle, whoever the hell this, mini-me Elon Musk is. And it says, the people need the information. That is what FOIA is about. And sure enough, I'm finding that you're likely to win it. There'll be irreparable injury if you don't get this information because you're coming into the appropriations process. So I think it's the best sort of fit of all the various cases that have gone through with Doge, and he, I think, writes it up really cleanly. So we'll see if they appeal, but I think he's made a really solid sort of initial analysis why the public has a need to know, and soon. Exigently, there's other things under FOIA that says, you don't have to wait the 6 months while the bureaucrat goes through this and that. You get to know right away. This is one of them because the appropriations process and money running out come Friday.
Now, this opens up the floodgates also. This was the first one. So if you think about, poking that first hole in the wooden ship and then the water starts to come in, others are going to be following this and looking at this analysis because there are a lot of groups, from the veterans groups that are having their lives destroyed to the people in NIH and the CDC, to the people working in the national parks, to the Department of Education and Labor and the probationary employees. You can imagine everybody who wants this discovery now and what's actually going on behind the scenes as Doge. And you can imagine that Elon Musk and his team of Mr. Big Balls, or whatever they're calling themselves these days, do not want these records turned over. The order by Judge Cooper also included a preservation order that basically says, I'm hereby ordering Doge and all of the entities it's communicated with that you cannot delete anything, destroy anything. Everything needs to be segregated immediately, all of this electronically stored information. And this is the page on 36 where Judge Cooper goes over this analysis. And he's saying, here are the issues why we don't think that Elon Musk and Doge are going to be forthcoming. Crew also notes reports that USDS employees have refused to identify themselves when requested to do so by career officials, further suggesting that the agency is operating with unusual secrecy. It goes on to talk about how, and although Crew requested assurances of FRA compliance from USDS, defendants apparently did not even respond. It goes on to say, the evidence gives rise to the possibility that representatives of the defendant entities may not fully appreciate their obligation to preserve federal records. This is especially true for USDS, many of whose staffers are reported to have joined the federal government only recently, and to put it charitably, may not be steeped in document retention policies. That being said, the court need not make a finding of bad faith in order to enter a document preservation order. Hint, hint, we all know that. This is what I'm doing now. You see what I'll do in the future. And that's clear to any lawyer what the judge was saying right there. Harry, I'll give you the last word on this.
Yeah, and also, I mean, in going through the history, he doesn't hammer them, but he notes for the record, in case he has to hammer them down the line, the many different ways in which they can. Or, there's a record now, they're coming to court and saying, oops, the dog ate it, or we'll get back to you. And it's an interesting position now for the federal courts. It's coming up in a couple cases, including the aftermath of the Supreme Court decision, Ben, which is, you have this relationship with the executive where you come and say, here's the law and do it. but you have to be a little cautious and gingerly, because if you say do it by tomorrow and they come in with some difficult to decipher kind of excuse, you're already precipitated the kind of constitutional showdown. We said Thursday at 12, and you're here, and it's time to pay the check, and you say we don't have any money in the bank. So Cooper is wisely saying, and this is what's also happened in the Supreme Court case involving USAID, as soon as practicable, I want to know right away, and this is the hearing that's coming up Friday, what's out there, but that you can tell me right away. But adroitly and with sophistication, these are the judges who handle these kinds of cases all the time, not setting up themselves for failure, setting it up to be able to push on them, and if necessary, do more kinds of orders or coercive measures, even up to contempt, but leaving a little play in the joints, because they know the real possibility that they're going to come back with some kind of crazy excuse. So okay, they don't want to. They'll still want to be able to roll with the punches there and get the information out as soon as possible.
There you have it, Harry Litman, Talking Feds podcast, Talking Feds YouTube, and the Talking Feds Substack. Please subscribe to all of them. Talking Feds YouTube, Talking Feds Substack, Talking Feds podcast, where I get my legal news. Harry's the best in the biz, and he's got the experience that we need right now more than ever. Thanks, Harry.
Hey, thank you, Ben.
Can't get enough Meidas? Check out the Meidas Plus Substack for ad-free articles, reports, podcasts, daily recaps from Ron Filipkowski, and more. Sign up for free now at MeidasPlus.com.